everyone, and welcome. Thank you for joining us tonight for this special gathering in honor of Hrant Dink. I think I speak for all of us at the Armenian Institute when I say that we are incredibly proud to host this annual event, both with and for our community, as a moment of remembrance, reflection, and renewed commitment to the values that Hrant stood for. As many of you well know, Hrant was a Turkish-Armenian journalist, editor-in-chief of the bilingual newspaper Schabas, and a courageous advocate for freedom of expression, minority rights, and dialogue between Armenians and Turks. At a time when such conversations were met with hostility and censorship, Hrant insisted on speaking with honesty, compassion, and moral clarity. His assassination on 19 January 2007 was not only a tragic loss of life, but a profound loss for journalism and human rights globally. Yet, his voice continues to resonate through memorials like this and through ongoing dialogue and through the work of those who ensure his ideas are not forgotten. That said, we are especially honored tonight to acknowledge Nuritsa Natosyan, whose relationship with Hrant Dink was both deeply personal and profoundly creative. Nuritsa, who many of you know from our community, is an author and the director of the first documentary made on Hrant Dink, based on their own conversations. That award-winning film, Hrant Dink, Heart of Two Nations, offers an intimate and powerful portrait of Hrant, capturing his humanity, his courage, and unwavering belief in dialogue. And as a side note, if you haven't seen it, I do highly recommend it. It is available for streaming on our YouTube channel. So if you have any questions, we have two volunteers and myself happy to direct you there afterward, and you'll be happy to speak with the director herself. But through this work, Nuritsa has played a vital role in preserving Hrant's voice and bringing his story to audiences around the world. So without further ado, I present to you Nuritsa and invite you to the stage, who will be introducing our speaker for the evening.
Good evening, friends, ladies and gentlemen. It really gives me great pleasure that you have the time and the energy and the disposition to come together again tonight, because as in other years, as Erin remarked, we have marked this evening and in various different ways, where Hrant was cruelly murdered. Would have been 72 now, and he's been robbed of 19 years of a life in which he would have written and edited and spoken to change the hearts and minds of people for a culture of truth and dialogue between Armenians and Turks and others. Since I was lucky enough to know him as a friend and was able to bring him to London with the Armenian Institute, and we filmed his visit and talks, I feel as though we have a special connection. Hrant came here in 2005. It was the 10th anniversary of his bilingual weekly paper, Agos. And actually it was the first time that he was granted a visa to travel out of Turkey, and we were on tenterhooks to see if he would actually get it. So it was the first place he went abroad from Turkey. And his legacy has been huge and ever growing, especially for young people. And tragically, to our great loss, his life was cut short in a brazen shooting outside his newspaper office in daylight. His young killer was sentenced to 23 years, but has only served 17 years of that and is now released and at large. The family has challenged this early release, and the Istanbul High Court ruled that they have no grounds for doing it because, and I quote, "The killing did not directly harm his family." So they have no grounds for challenging. And so the true perpetrators have still not been brought to justice. Today, many events have been planned in Istanbul and all around the world. In the year of his death, 2007, the Hrant Dink Foundation was immediately established to develop a culture for dialogue and demand for democracy for people of all ethnicities and cultures, and it runs a vigorous program of publications, conferences, research, education, again, especially for the young. And today, the Hrant Dink Foundation will have seen hundreds, if not thousands, of supporters who gather outside his former newspaper office of Agos in Schabas Street, which has now become a site of memory. Now, what a great privilege it is for me to introduce today's speaker. Professor William Schabas is the outstanding legal expert on genocide today. I also welcome Penelope, his wife, a fellow Cypriot, who seeded this lecture in actual fact. And I just want to read you this amazing CV. Professor Schabas is a preeminent Canadian academic and international human rights lawyer. He's widely recognized as one of the world's leading experts on genocide, capital punishment, and international criminal law. As a foremost authority on international criminal law, frequently cited by the US Supreme Court and the Supreme Court of Canada. He contributes to the movement for worldwide abolition of capital punishment, which I did not know. He is known for working to establish the International Criminal Court, the ICC, and his expertise in the Genocide Convention. He is Professor of International Law at Middlesex University, and he's also Emeritus Professor at Leiden University and the University of Galway, Honorary Chairman of the Irish Centre for Human Rights, and invited visiting scholar at Paris School of International Affairs. In London, Professor is a door tenant at the chambers of the 9BR in London, which means he gives evidence in court on special topics. He has appeared as counsel before several international and national courts and tribunals, including the International Court of Justice and the Grand Chamber of the European Court of Human Rights. Professor Schabas holds BA and MA degrees in history from the University of Toronto and degrees from the University of Montreal. He is the author of more than 20 books dealing in whole or in part with international human rights law, including, I quote, the International Legal Order's Color Line, Race, Racism, and the Making of International Law. And, perhaps more germane to what we're going to talk about tonight, his other book, Genocide in International Law, of which the third edition appeared in 2025 with Cambridge University Press. And he added that sadly it is actually much updated in the light of many recent developments in the world. Professor Schabas is an officer of the Order of Canada, a member of the Royal Irish Academy, and I can't wait to hear him speak.
Thank you, Nurit. I think I'm going to stand to speak. And the arrows, where was there?
Yes, forward.
Run the arrows.
Yeah. One more, maybe. There you go.
That's the beginning, yeah. It's a very simple, there's not a lot to read on my slides. I want to say what an honor it is to be able to participate in this day of commemoration of Hrant Dink. I know that events are going on throughout the world, really. I saw on Facebook reports of what was going on in Istanbul earlier today, I think. And to be able to participate in paying homage to this great person is really a special privilege for me. I don't know how much of Hrant Dink's material, his writing, is available in English, actually. I went looking for some of it, and I sort of took a shortcut because there were quotations from him in the judgment of the European Court of Human Rights. And so I went to them, and I picked one out which is also relevant to what I want to talk to you about a little later today, which is the subject of genocide. This is called The Armenian-Turk. That was the title that was given to what he wrote, and I've just got a little excerpt about a diaspora needing specific reasons to preserve its identity, and that the past of the Armenian diaspora, like that of the Jewish diaspora, was marked by genocide, the non-recognition of which was a factor of destruction for Armenian identity, the obsession with having their status as victims of genocide recognized becoming the raison d'etre of Armenians. The fact that this need of the Armenians clashed with the indifference of the Turks, unlike what had happened with the Jewish genocide, which the Germans had recognized, explaining why the trauma of the Armenians remained vivid. He got in serious trouble for writing this. He was prosecuted under an offense under Turkish law called denigrating Turkishness. There were several, I think there were 9 articles that he was prosecuted for, and this is an excerpt from one of them. And after he was convicted, he had a 6-month time horizon in which to make a complaint to the European Court of Human Rights. And so he filed his complaint at the European Court of Human Rights on the 11th of January, 2007, 8 days before he was murdered. The judgment, and this is my area, it's what I work with, the judgments of the European Court of Human Rights, and as Naritza mentioned, I've also been there as a lawyer arguing cases before the European Court of Human Rights. This is a judgment. This is the title page. The judgment in the case of Dink versus Turkey. It's in French. The European Court of Human Rights is a bilingual institution, and sometimes the judgments come out in both languages, and sometimes they come out in one or the other. And for reasons unknown to me, well, I have a suspicion one of the reasons why this one is in French. The presiding judge was Françoise Tolkens, a Belgian judge who is a friend of mine, and she presided over the 7-judge panel that adjudicated this case, a famous case at the European Court of Human Rights. They have, 2,000 cases a year at the European Court of Human Rights, so it has to be special to stand out, and Dink versus Turkey is an extraordinary case. He filed the case, and of course then he was murdered days later. There's a rule at the European Court of Human Rights that it's possible for a next of kin to take up the case and to continue it, even if the person who is the applicant is dead. And his family joined the case. His case was originally filed about freedom of expression. He was confined to the article dealing with freedom of expression in the European Convention on Human Rights because he'd been punished for expressing his views of tolerance, of sympathy for minority rights, and so on. But the family joined in, and 4 family members actually were united with the case. That's why there are a series of numbers there, different applications. And that was about the murder of Hrant Dink and the inadequate or almost non-existent investigation that was carried out by the police and the investigative authorities in Istanbul. So the judgment is famous, maybe not so much for the ruling that the Istanbul authorities, the police, had done an inadequate investigation into his murder. That was in some ways legally more routine because there were many judgments like this, but it was a very damning finding for the Turkish authorities. But really the more important part is about freedom of expression. And I have a quote here, I have a little phrase there about what was decided. Freedom of expression, which is Article 10 of the European Convention, creates a positive obligation to to create a favorable environment for participation in public debate by all persons without fear. In other words, a state has an obligation not only not to deprive you of your freedom of expression by punishing you for expressing your views, as they did to Hrant Dink, but they also have a positive obligation to protect you when you're threatened, when your views are threatened, maybe not just by the state, but by others, by third parties, including those who conspired, because it was a conspiracy, to take his life. This is a quote I'm translating from the French in the judgment. The positive obligations under Article 10 of the Convention require states to create, while establishing an effective system of protection of journalists, a favorable environment for participation in public debate by all the persons concerned, enabling them to express their opinions and ideas without fear, even if they run counter to those defended by the official authorities or by a significant part of public opinion, or even irritating or shocking to the latter. And this idea has been repeated over and over again in cases of the European Court of Human Rights, and whenever it's cited, we have the fingerprints of Hrant Dink on the citation. There's a footnote, and his name lives on for many things, but amongst others for the fact that this was a result of the application that he filed at the European Court of Human Rights. Some of you must know this book. Maybe. Has everybody read the book? Maybe. In German? I have several copies of it in my library. I first read the original English translation, which apparently was cut short from the German. And there's more recently, there's a new translation as well. I have 5 grandsons, and on their 13th birthday, I give them a little collection of books that I want them to have. Books that influence my life, and that I hope will influence theirs, and that maybe they may, teenagers don't read books the way I did when I was a teenager, unfortunately, but I'd like to think they have read them, or they will read them, and they'll cherish them as well. And of course, one of those books, there are 3 of them. One of them is The 40 Days of Musada by Franz Werfel, this amazing story that Werfel wrote. It was published in 1933. Werfel was a German Jew who fled from Germany. And of course, there are echoes throughout the story of the people of Musada that resonate with what was going on in Nazi Germany as well in the early 1930s. And as you probably know as well, there are whole stories about this, attempts to make a feature film in Hollywood that was obstructed by the Turkish embassy, and so on. I suppose that this man might have read the book. This is Raphael Lemkin. I mentioned and I showed you the quotation from Hrant Dink for which he was punished, where he refers to genocide. Franz Werfel didn't refer to genocide. The word didn't exist in 1933 when the 40 Days of Musada was published. This is the man who invented the word. His name was Lemkin. He was born in what is now Belarus, went to law school in Lviv, now Lviv, which was then Eastern Galicia, part of Poland, and now of course part of independent Ukraine. Lemkin then practiced law in Warsaw after getting his law degree. He was sent as a junior prosecutor to a town called Brzeżany, which is in eastern Ukraine, where my grandparents were born. And after the war, or during the Second World War, he himself was a refugee. He went to the United States and he wrote a book called Axis Rule in Occupied Europe. And this is where we see the word genocide for the first time in 1944. And he spent the rest of his life campaigning for the criminalization of genocide, for its recognition as an international crime, and after the Genocide Convention was adopted in 1948, that he played a great role in its creation. He campaigned then for states to ratify it and to enforce the Genocide Convention. There's his tombstone at the top, which is in the cemetery in Queens, New York. I took that picture, and a friend of mine took a picture of me laying a stone there on his grave. Lemkin was at the Nuremberg trial. He watched part of the Nuremberg trial, but he was disappointed with the Nuremberg trial because the Nuremberg trial dealt with genocide under the heading of crimes against humanity, but only after the war had begun. And this was because of the limitation on the law, on international law, that was put there by the Nuremberg Tribunal, or by those who created the Nuremberg Tribunal, the United States, the United Kingdom, France, and the Soviet Union. And they didn't want to prosecute atrocity crimes that were committed before the war began in Nazi Germany from 1933 to 1939, because they were afraid of setting a precedent that states could be held responsible for atrocities committed against minority groups within their own territory in time of peace. And I think you could perhaps understand, take a guess anyway, of why the United States would have been anxious about that, and why the United Kingdom would have been anxious about that, and why the French and the Soviets as well would have been nervous. So Lemkin said, I'm going to fix that. And he said, and he campaigned for genocide to be recognized as a crime that could be committed in time of peace as well as in wartime. The first output that he contributed to was a resolution of the United Nations General Assembly in December of 1946. And I put this up just because I want to draw your attention to a line in the preamble of the resolution. It's well, it's right here, I'll point to it. Many instances of such crimes of genocide have occurred when racial, religious, political, and other groups have been destroyed entirely or in part. And this is a clear demonstration of the fact that when genocide was codified by the United Nations, first in this resolution in 1946, and then 2 years later in 1948 when the convention was adopted, there was no sense that this was a crime that could be committed in the future. There was also an important message that it had been committed in the past as well. And in fact, when the first court case came to the International Court of Justice about genocide in 1951, the United States of America made a submission to the International Court of Justice where they referred to past genocides, including the genocide of the Armenian people by the Turks in 1915 and 1960. This is our famous definition of the crime of genocide. It's a narrow definition. It's not meant to cover all atrocities. It's meant to deal with the intentional. It says with intent to destroy, in whole or in part, a national, ethnic, racial, or religious group. Now, lest you think I'm going to give you an entire lecture about the international law of genocide, I'm not going to do that. If you want, you can come to the Zoryan Institute in July this year. Every year, the Zoryan Institute in Toronto delivers a course on genocide. And for about the past 20 years, I've been a lecturer there. And so I spend a day with the students at the Zoryan Institute talking about the law of genocide. I don't plan to do that today, but I want to talk about a few of the highlights of this that you may find interesting. This is a quote. This is the quote actually from the submission by the United States of America to the International Court of Justice. I found that, and we hauled that out some years ago when the United States government was saying that they could not recognize genocide of the Armenians, that this would not be the right thing to do, and we pointed out that they'd already done it in the statement that they submitted to the International Court of Justice. You see there, they refer to the Roman persecution of the Christians, The Turkish massacres of Armenians, the extermination of millions of Jews and Poles by the Nazis, are outstanding examples of the crime of genocide. Well, the International Court of Justice is the world court. It sits in The Hague. This is the court where you go with genocide cases. There have been something like 21 applications now to the cases at the International Court of Justice dealing with genocide that are brought to the court by virtue of this Genocide Convention, which was adopted in 1948. The court has yet to rule against the state that it committed genocide. Of those 20 cases, most of them have been thrown out on technicalities. And 2 of them were thrown out. They were decided, as we say, on the merits, where the court examined all the evidence. They dealt with the wars in the Balkans. And the court came to the conclusion that Serbia had not committed genocide in Croatia or in Bosnia and Herzegovina. And it's characteristic of a lot of the debates about genocide, because it is a challenge to try and draw a line between persecution of minorities that would not get over the threshold into the category of genocide. You might think 20 cases doesn't sound like a lot, but I have to tell you, the International Court of Justice, the World Court, in its entire history, it's 80 years old. This month, it was set up 80 years ago after the Charter of the United Nations entered into force in 1946. And they've only had 201 cases. So genocide and cases under the Genocide Convention are actually 10% of the cases that have gone to the International Court of Justice. And as I mentioned a minute ago, none of them have really amounted to very much. And the 2 most recent cases, Bosnia and Herzegovina against Serbia and Croatia against Serbia, decided in 2007 and 2015, which basically rejected the claims, kind of sent a message to states that from the International Court of Justice saying, don't come back with genocide. It's not going anywhere. Don't take your cases here. Deal with genocide in a criminal court, like the International Criminal Court. That's where it should be dealt with. But hauling a state up before the International Court of Justice about genocide, it's not going to work. That's how I understood things a decade ago after that judgment in Croatia versus Serbia. But it's not how states have behaved. And one of the really astonishing things in the last 5-6 years is that governments, one after another, have come to the International Court of Justice asking them to make a ruling about genocide in the Genocide Convention. These are the 4 cases that are currently pending. I'll just talk you through them in a minute and tell you a bit what's going on there. But the other thing that's happened, besides those 4 cases that have been filed, there was a 5th one that was filed not even a year ago and got thrown out again, kind of on a technicality, is that we have something like 50 governments have intervened in the cases. They're not even part of the case. And in the whole history of the International Court of Justice, there are probably 5 countries that have intervened, typically in a case where 2 states are fighting about their borders, and a country comes and says, we might be affected by this too, so we better be at the party. We want to be involved in this, because if you adjust that fishing zone, it might affect us. But the 50 states who've intervened in these genocide cases, they just want to make sure that genocide is dealt with. And as I say, this has all happened in the last, since 2020, basically. The first interventions were in 2022. The United Kingdom has intervened. The United Kingdom intervened with 5 other states in the case of Gambia versus Myanmar. Deals with the allegations of genocide against the government in Myanmar. And together with Canada, France, Germany, Denmark, and the Netherlands. The United Kingdom agreed. They made a submission to the court 2.5 years ago, I think at the beginning of November of 2023, saying, we support the Gambia in their case against Myanmar. We agree that Myanmar is committing genocide. But you know, in the past, the court has been rather conservative in how it interpreted the crime of genocide, and we want you to be a little more generous, to make it easier to prove genocide. They said, trying to help Gambia in its case with Myanmar, they said, there are some things you should be looking for in establishing when genocide is taking place. They said, when children are the victims, that's a telltale sign. When the children are seriously affected, that's a time to be looking for genocidal intent. They said when there's mass displacement in the territory, within the territory, not just expulsion, look for that as well. These will be indicators that will point you, that will help you to conclude that there's genocidal intent. Now, when they did this, they did not anticipate that 2 months later, not even 2 months later, South Africa was going to file a case against Israel. And what they did in their submission in the case of Gambia versus Myanmar was set out the legal arguments for South Africa against Israel. I think there must be some lawyers in the Foreign Office and in the foreign ministries in France and Germany and Canada and the Netherlands and Denmark saying, you know, this was an own goal. We shot ourselves in the foot. Why do we do this? But it's one of the interesting features of all this. These debates that are going on here, it's countries of the North and countries of the South. They don't see the world the same way, but they have to go before the same 15 judges and set out their arguments. And sometimes to win an argument that's going to help condemn Myanmar for genocide, you may end up supporting the arguments against your friend, the government of Israel, as well. So the Myanmar case, there are 4 of them that are now before the court. It takes years for a case to kind of ripen at the court. It's like a civil case here as well. People say, why does it take so long? Try suing somebody before the court's here. You're going to wait a long time as well before you get into court. So it takes time. The Gambia versus Myanmar case was filed in November of 2019. And the trial in that case started last Monday. So they're now in the 6th day of the proceedings. You can go on the website, and it's not making headlines exactly, but the lawyers are very busy in The Hague before the judges of the International Court of Justice arguing about genocide in Myanmar. Whether or not it took place, Gambia began the case with a long presentation last week. They emphasized the narrative and the facts a lot. Myanmar began on Friday, and their argument on Friday and today was, you don't have the proof. You can't prove it. And it's one of the challenges in doing this, is to have proof that reaches a level that's acceptable for a court. It's not such a simple thing, and it's one thing to win an argument or to make a case for an NGO report for Amnesty International or for a Commission of Inquiry report for the United Nations. But it is another thing to try and win a court case where the burden of proof, the standard of proof, is beyond a reasonable doubt. There's another case filed by Ukraine versus Russia, Ukraine against Russia, which is a bit of an outlier. It's an odd case because it was Ukraine's way of trying to litigate the issue of the Russian invasion. And the court threw out about half of that case and said to Ukraine, you think Russia made a false allegation of genocide to justify the invasion? Well, you can't go after Russia about the invasion, but you can continue to prove that it was a false allegation. And so Russia then has answered and say, oh, you think it's a false allegation? We're going to prove that actually you did commit genocide. So this was an own goal. Ukraine is in the position now of having to prove that it didn't commit genocide, which is an odd result, but it is a strange case. And then finally, the case of Nicaragua versus Germany, which is about Nicaragua is suing Germany for its support of Israel in Gaza. And Nicaragua is charging that Germany failed to do its utmost to prevent genocide by its friend Israel, and also that it was an accomplice by providing material, financial, diplomatic assistance to Israel. So these will go almost like a chain, I think. That's probably the order that the 4 cases will go in. If Gambia loses, it doesn't mean that South Africa and Nicaragua will lose. I think that of all of them, the South Africans have the strongest case in terms of the evidence, I believe. If Gambia wins against Myanmar, and the court agrees that genocide was committed in Myanmar, I think Israel will be, as we say, behind the 8 ball. It's going to be pretty difficult for them to fight that off. So there are a lot of moving parts here in this litigation because we have these 4 cases, we have these different interests, we have these countries like the United Kingdom that want to condemn Myanmar but actually would prefer that Israel was acquitted, so to speak. And so all of that is going to be going on with genocide over the next 3 or 4 years. And for someone who's involved in this stuff, it's kind of exciting, very interesting to watch all this happen. And to see that this convention, adopted in 1948, started by Lemkin, to some extent in reaction to Lemkin's outrage about genocide in the Ottoman Empire, has been revived and is in a way more present in our lives than it's ever been. Well, genocide isn't just about these pending cases in the future, it's also a little bit about the past. Maybe some of you have seen this cartoon. It was in the International New York Times in 2050 on the 100th anniversary. And it's about the use of the term genocide retroactively, so to speak. And some of you may know that here in the Parliament, some years ago, a parliamentary question was answered by the spokesperson for the Foreign Office, saying that we can't use the word genocide to talk about what happened in 1915, because that would be giving a retroactive effect to the Genocide Convention. And that's just wrong. That's just wrong that you can't use the word. And as I pointed out, in the resolution that was adopted, for which the United Kingdom voted in 1946, it talks about genocide being committed in the past. And the Genocide Convention itself says that genocide has been committed at all times in human history. So the idea that the word can't be used is an idea that we have to reject. It's part of a larger debate about trying to apply our contemporary standards of human rights and justice and international law to events in the past. In another area, and Maritza mentioned the recent book I wrote about racial discrimination, which studied how that issue has been treated by international law through the history of international law. That we have an important international conference 25 years ago now called the Durban Conference on Racism and Racial Discrimination. And there was a declaration that was adopted, and there was a big quarrel there at the conference about how to characterize the slave trade. Now, the slave trade, in the classic sense, the chattel slavery, the mid-Atlantic passage and all of that, it's a historical event. It's not something we see. We have modern forms of slavery, but the slave trade, when we talk about it historically, it belongs to the past. There was a debate about how to characterize it. The countries of Africa and of the Caribbean, and more generally of the South, wanted to say, well, slavery and the slave trade, it's a crime against humanity and always was a crime against humanity. And the countries of the North, including this one, who have their own history about the slave trade, insisted that it's a is a crime against humanity and should always have been so. So it's this issue about whether we can use this language of crimes against humanity or of genocide to say that you committed it. So the debate can go back before 1915, of course. And most recently, where we've seen this argument taking place, it concerns Germany, which has its own history with genocide, as we all know, but it has some historic cases well before the Nazis came to power. The great case of genocide at the beginning of the 20th century was of the Herero and the Nama people of Namibia. This is my last slide. I'm closing with this. This is a memorial in Windhoek about the Namibian genocide. I wanted to put that picture on the cover of my new book. That's my new book. That's the third issue of my book that came out last year. And Cambridge University Press said, no, it's too brutal. You can't put that on the cover. So there, to my great regret. But I get to put it on the slide anyway. And Germany has acknowledged that genocide took place. So to go back to that little comment from the first slide, Hrant Dink, talking about how Germany had acknowledged genocide of the Jews, it took them a while longer to acknowledge the genocide of the Herero and the Nam, of the people of Namibia. But they finally did it a few years ago. But they have a cute formulation where they call it a historic genocide. And in their statements, they say, when we say it's a historic genocide, what we mean is it's a genocide, we acknowledge it's a genocide, but there are no legal implications. So as I said, this is part of a broader debate about the past. It concerns 1915 in Asia Minor, as we used to call it. But it also concerns slavery, the slave trade, and other genocides. And that debate is not yet resolved. This is going on. So there are broader consequences to this issue about genocide in the past. You know, I'm reminded of there's apparently an old Soviet joke about how, you know, we have a lot of clarity about the future, but it's the past that's uncertain. Well, thank you very much.